Well, ladies and gentlemen, if you're still with me, or if you just joined us, this is part two of Barbarians at the Gate. My name is Ben Gray. I am, as stated in part one, a amateur journalist out to expose egregious corruption within the Bristol Crown Court judiciary, or the Circuit Judge judiciary, and the higher court judges such as Mr. Justice Warby, Lord Justice Warby, Lord Justice William Davis, and many others. Part two deals with the aftermath, effectively, of the incident at Bristol Crown Court and its vicinity. This is what happens during processing in custody. The word processing itself bespeaks of not a particularly pleasant experience for those who are accused, and in my case also the accuser. What I shall do in terms of addressing my experiences in custody after being arrested on the 30th of November 2021 for various suspected offences, most of them assaulting an emergency worker. It is presumed, I never contested whether or not a CID officer who is, let's face it, sitting on his posterior it doesn't seem to me that any CID officer, plainclothes officer, who works on sort of the more intellectual elements of police enforcement or investigation could be considered an emergency worker, but I never disputed it. I'll say for the purposes of this documentary, and obviously I didn't contest it particularly in the proceedings. And of course, you heard me question whether or not these officers were emergency workers before Police Sergeant Scott Westbrook Smith. It's a very minor issue, and I'm not going to spend time on it. Let's assume they are for the purposes, but obviously my complaint is, as I've made clear during arrest, that I am not by any criteria creating a breach of the peace or proposing any sort of issue that involves violence or threat of violence. And under the ruling of the highest court in the land, under Laporte, there is no evidence of any form of breach of the peace if there's no violence or threatened violence from the person arrested. A person can be arrested. Indeed, since I made my documentary, there's been an incident where a man of Jewish origin is prevented by the police from entering the area where demonstrators against the Gaza campaign by Israel is being carried out in West London, on the basis that he is openly Jewish, and he is threatened with arrest under breach of the peace powers, because being openly Jewish in the area that he was proposing to go, where the demonstrators who are anti-Israel, the anti-Israeli campaign against the Gaza campaign is underway. So people can be and are arrested, even though they are effectively the victims or potential victims of crime from other parties. But I wasn't arrested under the prevent breach of the peace powers. I was arrested because I committed a breach of the peace, and therefore it is a completely different kettle of fish. And indeed, as we saw a few moments later, I am searched under Section 32 of PACE by DS Bale, the arresting officer, on the basis that I am a potential threat to myself, of serious harm to myself or others. So there can be no dispute that I'm allegedly arrested for creating the breach of the peace myself, because a breach of the peace has already occurred according to DS Bale. And of course, that is for the same reason I am searched a few moments later, conducted a body search, which I say was so intimate as to amount to a sexual assault in its own right, and certainly was an illegal search under Section 32, because there was not a shred of reasonable grounds to search me because I was a threat of violence to myself or serious harm to myself or others. So here we are in front of Police Sergeant Scott Westbrook Smith, with whom I have dealings and who has been involved in other false imprisonment, assault allegations against officers, and given a witness statement in some proceedings. I'm not going to go down revisiting all that. That would obviously sidetrack from the issue about my legality of my detention here and now, and it will be matters that will be for further documentaries. And of course, what I'm now dealing with in part two is what then unfolds as part of the investigation process. Indeed, I am detained, just to clarify, and obviously we'll come back to it in a moment, but I'm detained. Police can detain somebody who's been arrested for purposes of interview and so on and so forth. The officer who's detaining, in this case Scott Westbrook Smith, has the powers to release and have the interview at a further stage or have ongoing investigations. He has the power to say that there's not enough grounds to have arrested the person in the first place and therefore release the person. I think Section 37 of PACE gives him the duty to assess whether a person could be charged there and then and not need any further detention. Certainly he could be detained as part of a remand, but he can't be detained for investigation because there's enough evidence to charge him with there and then, and he's duty bound to make that assessment there and then. But in my case, I'm being detained purportedly to carry out a prompt and effective investigation. And of course, we shall see to what extent that investigation was prompt and effective from the documents I show you now. But of course, the first point I've made to Mr. Scott Westbrook Smith is the point that the reason given for my being arrested by PC Neal, who's I think technically the arresting officer, or I'm not quite sure what her role is because she wasn't actually present at the scene, but she's relaying notes that have been given to her by Doxy and Bale on the basis that I was not being calm, that I refused to calm down. Well, clearly that on no basis can that be grounds of arrest, especially if somebody's complaining, as I made clear to both officers, that I was the victim of assault from Henderson Ford, and therefore I was simply reacting emotionally to anybody that's been the victim of an egregious assault. And Westbrook Smith's attitude is to simply ignore any point that I've made, which is perfectly valid, that I wasn't originally detained legally, and therefore any suggestion that I've used violence, or I've spat at officers or hit officers to extricate myself or in response to being illegally detained, which is kidnap, as we've established in part one, under the criteria of having no reasonable lawful excuse to detain somebody, to remove them from one place to another against their will or by fraud, by force or by fraud, it amounts to a kidnap. Clearly, even if Mr. Westbrook Smith has no knowledge or interest in the law of arrest, the powers of arrest, or the criminal law in self-defense against that, he surely is obliged to pay some attention to the fact that what reason has been given to him for detaining me in the first place has no basis in law at all. If police can simply arrest anybody for allegedly not being calm, of course no officer can know whether somebody's actually calm internally. They could be acting out, they could be being perfectly calm, but happen to be shouting or whatever the circumstances are. Then of course officers could arrest everybody who's not heard a football match, everybody who's in an agitated state in a conversation, or being leery in a pub, or simply in any sense being a human being, which is effectively what not being calm is. Nobody, especially this is the COVID, we're still in COVID, whether or not they've been the victim of an assault themselves. And of course, Westbrook Smith is to simply monotonously ignore the perfectly valid point, because he's immediately colluded. He even effectively boasts about the fact that he knows Bale. Indeed, it's worth pointing out that Westbrook Smith used to be in CID, and I don't know whether it counts as a demotion, but he was put on. He ended up as the police sergeant custody officer, which probably isn't quite as exciting as I think it's not even as highly paid as a CID officer. I suppose I can make out Bale and Doxy are on about £50,000 odd a year for not doing very much, as far as I can tell, and certainly for, in my case, kidnapping members of the public that they're supposed to be protecting. But there you go. You see quite clearly corruption in every essence of the word, from Westbrook Smith's complete ignoring the fact that it can't possibly be, even to a layman, sound like justification to arrest somebody, to deprive them of their liberty and take them to a police station, as Bale was intending to do, regardless of however I reacted to the arrest, on the basis that they're not being calm. And then, of course, we have the search, and we'll come in a moment to the CCTV and what happened to that, and what the officers are supposed to do with that, bearing in mind that I complained twice that I've been viciously and nastily assaulted by the searching officer, PC Jack Bartle. You can see I'm trying to be jovial with him, but indeed Westbrook Smith orders Bartle not even to talk to me. So rather than try and diffuse or treat me as a human being, and you will notice when I come to the custody records, for instance, I'm referred to continually as the detainee. So it's a way of completely dehumanizing the fact that somebody's been detained who may well be the victim. There's still supposedly an investigation underway to determine who's the victim of what. Bearing in mind there's no independence in any investigation, where the person doing the investigation, in this case it's a PC Phelps and a PC Joshua Stevens, Jofficer, Stevens and Phelps, two sort of sides of the same coin in the sense that they're both the investigating officers, although it's usually just one officer, who are investigating far senior officers, plainclothes, respected CID officers, for the alleged counter allegations of misconduct against them. I mean, it's preposterous. It's getting the junior staff to investigate the manager in effect. But we'll come to that in due course. But of course, again, Scott Westbrook Smith, as far as I can tell from the custody record, makes no record of the fact that I've complained about being sexually assaulted by PC Bartle. You can see here on the footage is the manner in which his hands go right between my legs to my genital areas. He makes physical contact with my genitals. In doing so, he notifies me that's what he's about to do. So there's no dispute that's what he does. And before that, he immediately goes to my elbow to squeeze it. And just for the record, in the proceedings that followed, I think it's 2021-0023, but I may be wrong on that. But the T 2022 or 21 is the case reference for the proceedings that eventually occurred at Bristol Crown Court. So everything I'm saying, any dispute about what Recorder Sellers did or Judge Lawrie did, who had charge of this case when it finally came before those two obscenely corrupt and villainous judges and recorders. And of course, there's another update in terms of what's happened since I made my last, in part one of the documentary, and that is, of course, Recorder Sellers, or junior barrister Sellers. So he wasn't even a silk at the time. He was the barrister, the recorder in my proceedings. Has now been promoted to a circuit judge. His services to corruption and evil, certainly in terms of the case in which I was involved, has been justly rewarded. And didn't I say in my last documentary how Doxy had been promoted? He was promoted from detective inspector to detective superintendent. By the time he was up before the court, he was on the witness stand in proceedings against me, being accused of colluding in sexual assault and kidnap, as was the basis of my defence. And of course, because Recorder Sellers then colluded in all the obscenities and evil outrages just in that case, let alone all the other matters that were put before Recorder Sellers in terms of my being abused by other judges and police officers, all of which was suppressed from going before the jury. Even the formal findings of false imprisonment, and we'll come to the trial, of course, as part 3 of these documentaries. But even before Recorder Sellers had any involvement, Judge Lawrie forbid me from putting any of my what's called bad character, non-defendant's bad character. So any evidence that I was justified, even if I was being lawfully detained, even if I was being not sexually assaulted and assaulted by the officers during my illegal detention by the officers in question. The fact that I've been repeatedly falsely imprisoned and assaulted by the police in 5 separate occasions is clearly a reasonable grounds of self-defense and fighting against that, and trying to resist being subject to more of those further abuses. And all of that, there was passing reference in only the most minor passing reference by Recorder Sellers to the jury in summing up, but provisionally it was also pressed by Judge Lawrie without even a hearing, as he's required to do by law, and he said none of this is going to go before the jury, not least of which including the many findings of false imprisonment and assault by the same constabulary and colleagues of Bale and Doxey in the recent past, as well as the more distant past. But I am jumping ahead of myself. So well, let's look at the custody record, shall we? And obviously investigation. So let's get on to what the investigation entails. So, of course, ladies and gentlemen, you'll be aware that the first port of call for somebody that's been arrested and is in custody, and in my case has been repeatedly falsely imprisoned by the same constabulary, is legal representation. We all know that if you're rich, you can just simply get on the blower to. Certainly, I'm not trying to be stereotype too broadly. But people like me, and there's no dispute that I've got many convictions. I've been in a lot of trouble with the law, in quotation marks. Of course, the whole point of this documentary is to prove the extent of corruption and injustice that resulted in those convictions. But take them at their highest, then of course that would mean I'd have some sort of barrister, lawyer, judge who would barrister and solicitor who I would know, who would deal with all my cases and get me knockdown sentences after I pleaded guilty and vigorously defend me if I was pleading innocent. But of course, none of that is available to me. I have complained bitterly and in some cases successfully about corruption from various firms in Bristol, some of which have closed down since. But Alan Hall is one such who I successfully complained to the Law Society about not representing me properly when I was being accused in 2008, I think it was. And Kelsey and Hall. There are many other firms I could go into. There's Daniel Wood or Woodman. Many of them who I've complained about who are in cahoots, I allege, and of course they will be referred to in further documentaries of all that they're in cahoots with all the torture and criminal abuse and false imprisonments and kidnaps and perjury and perverting justice, all the things that I accuse Judge Warby of being the sort of the umbrella judge over these matters. But I'm still entitled to legal representation, and you can hear when I say at the custody desk I don't want legal representation because I mean I want it, but I'm not going to get it. No one will represent me. Well, I changed my mind because after a few hours in a brightly lit cell, when you've got every single officer, not every single officer, but certainly all the officers involved in my case, gunning for you, they're the complainants and they're the people I'm complaining about. I sort of changed my tune and I said I did want a solicitor and I was entitled to one and left it up to the police to sort it out. The system is you have what's called a duty solicitor scheme, whereby it's simply a taxi rank system whereby when somebody's brought into custody, if they're on legal aid, the police will contact and say the duty solicitor call desk. And we say we've got this suspect in custody, and he's asking for representation, and then whoever comes up on the roster will be appointed to represent me. And in my case, it was a person called Andrew Ray, whose face I can't find online, but is certainly a solicitor who works for Nelson Legal, and I've got Nelson Legal. I've got Mr. Nelson's face here on the screen, and I'll blame him entirely, because although Mr. Ray obviously was responsible for not representing me and all the things that I'm about to tell you about, it's obviously Mr. Nelson who's his boss, and he deals with Mr. Ray's accountable to any misconduct in the first instance to Mr. Nelson. But I contacted, after I was finally released from custody and released from Hallfield Prison and could get to a computer, I contacted Mr. Nelson to address the following issues with him. Well, let's look at the custody record. The custody record states at 19:15, so now I've been in custody several hours since I was booked in by Westbrook Smith on the same evening as the day I was detained. And the custody record states Andrew Ray of Nelson Legal has picked up the call, given detail, call put through to cell, DP, that's Ben Gray, that's detained person, because I'm totally dehumanized, as you can see. I'm just simply DP. When of course they're talking to you, they try and use your first name, or certainly once they've got you in custody, you lose all respect. You're no longer Mr. Gray. You're just the first person's name by a complete stranger who may or may not be falsely imprisoning you. But in the record, you're completely dehumanized to DP, as I've already said. So DP has refused to move and was shouting at the solicitor. He refused to speak into intercom and kept saying he could not hear him when he clearly could. Well, the person who made that record, and I think that's Bradshaw or whoever it is, the name will come up in due course. Sorry, it's Mr. Daly, excuse me. So obviously Mr. Daly can't possibly say what I can or cannot hear in the tannoy system. The tannoy system is in the wall of the cell. The cell is extremely echoey. It's simply closed walls. You've got a toilet there which has a camera pointing at the toilet. So although it's supposed to be blacked out, you can clearly see from the blacking out on any when they show it on TV, it doesn't cover up everything. That's it. So the thick walls simply make it any noise at all simply echoes and is reverberated in the same way any amplifying device amplifies noise. And of course the tannoy system is already distorted. And of course I've got no idea who I'm speaking to, and I've got somebody on the tannoy saying that they're a solicitor or saying they're this, that, or the other. I'm extremely disorientated. I'm claiming to have been kidnapped. But in any event, how on earth can Daly say what I could clearly hear and not hear in terms of having to communicate with Mr. Ray? And of course, Mr. Ray is well aware that he even later it's indicated that he's going to give me initial advice before interview. And to some extent, we're already discussing the case by the fact that he's merely contacting me, which is supposed to be confidential. But Mr. Ray is quite happy to have an open conversation about how I should conduct myself and give me initial advice before he's even bothered to come down to the police station, in full hearing of not a police officer, a custody officer, but obviously effectively somebody who's part of the police team in the station. And of course, any incriminating evidence I may blurt out or may be misconstrued, or any of my conduct, as indeed was the case here. I was accused of shouting and at the solicitor, and that's already an alleged form of misconduct that can then be used against me, which is being handed over by Andrew Ray because he's allowing the supposedly confidential conversation to go on in full hearing of a custody officer related to the people who are accusing me. And we have another record here. This one is 11:51 of the same night of my arrest, 30th of November 21. DT visited in cell. I don't know what DT stands for. Maybe that's a spelling error on my part, but obviously you'll see the custody record coming up on your screen here. Visited in cell, had requested a drink of water. He then proceeded to spit at me, which missed and hit the water over me. He shouted abuse at me and continued to try and spit at me with his hands on the hatch, preventing it being raised. P.S. Harris informed. This was Neil Bradshaw. He became a complainant in this case, and I got 10 months for the splashing of water on him by Recorder Sellers, or as part of my overall sentence on conviction. But so he's the complainant now, but he carries on liaising with the solicitor or dealing with issues about whether I have legal representation supposedly defending me against allegations from Bradshaw. So the conflict of interest is to the extent that Mr. Ray may as well be the complainant or one of the complainants, and indeed he was, as we shall see in a moment. The next record is 12:20. This is now the following night. Dealing with the next record anyway. This is now from Police Sergeant Harris. Now he's effectively in charge of the custody officers and the lower ranking officers, the investigating officers Stevens and Phipps, or Phelps, or Phipps, I think it is. And he says here, I asked him on several occasions if he would like to nominate another solicitor. I gave him one final option of nominating a solicitor, or he would be interviewed without one. Now, of course, this is because at some point, and I still don't know at what point it was, but at some point, Mr. Ray withdrew from representing me. It was alleged in the record, or it was suggested because I was shouting at him on the tannoy, that was actually dismissed by Mr. Nelson when I complained to Mr. Nelson about Ray withdrawing proceedings. And so when Mr. Ray actually decided not to represent me, and why, are matters still in dispute, haven't been resolved by the Solicitors Regulation Authority, all of which will come to in due course. But the fact remains that Mr. Harris that Mr. Ray has withdrawn representation. I'm no longer being represented. I am entitled, if I so desire, under Section 54 of the PACE Act 1984, to legal representation, to legal advice before interview. That is a statutory entitlement. And I still want representation. There's no dispute that I've changed my mind. It's on the custody record that I now want legal representation. And Mr. Harris, P.S. Harris, now gives me the ultimatum that I have to nominate a solicitor. Well, we know that I don't nominate solicitors, that somebody's on legal aid. Certainly, every officer who's ever had dealings with me, which will certainly include Harris, knows that no solicitor will represent me anywhere on the Western Circuit, whether that's here in Bristol or cases that have been before me down in Exeter or Portsmouth, etc. The idea that I'm going to nominate a solicitor off the back of my head is both nonsense, because no solicitor would represent me even if I knew one. Even if there was potentially one that would represent me from outside Bristol, for instance. But in any event, the duty solicitor scheme doesn't involve nomination from the detained person. It is simply the whichever solicitor comes up on the system, on the duty solicitor scheme. That is how Andrew Ray came up. And of course, Andrew Ray was well aware of this situation when he withdrew representation. At some point, he contacted, there is a note which will come up in a moment, where the duty solicitor scheme, this was provided by Mr. Nelson himself, the duty solicitor scheme had refused to contact me at all, but where Mr. Ray has at some point, about 11 or 12, unfortunately I can't find the time stamp, it's missing a little bit from the photocopy that I've got. I've contacted the firm to get that, but in the meantime it's certainly sometime around 11, 12 at night, that night. When Mr. Ray became aware that Mr. Ray's grounds, as given by Mr. Nelson, as to why he withdrew, is not because of my conduct on the day of my detention on this day, but apparently in some other matter, I have threatened and been abusive to Mr. Ray in some other circumstances. I've asked Mr. Nelson to provide when this was, what evidence, what form of misconduct this was, and they've refused to provide any explanation surrounding that at all. And of course, I've never been arrested or charged or investigated about any conduct towards Mr. Ray in any circumstances. I complained about him when he worked for Palmer and Ray, to the Law Society, as was then called, I don't know how. I don't think that I was successful in that complaint, but there would presumably be some record of what assault or threats I made towards Mr. Ray, but none were given. When Mr. Ray became aware of this history we had is again a complete mystery. He, at some point after 7:15. He decided that he knew me from another occasion and he wasn't going to represent me. But the custody record, as we shall see, states that Mr. Ray was still agreeing to represent me, just not attend the police station until at least 11 or 12 at night. Of course, this is the extent of madness and corruption that is going on. It's quite clear that Mr. Ray, whether it's a personal vendetta or because he knows that I'm about my campaigns to expose egregious corruption within the judiciary generally, and the collusion between the police and the judiciary, and the CPS and the police and the judiciary. And he doesn't want to be part of that, especially because the incident happened in Bristol Crown Court, and therefore he will probably know, because he'll be in and out of the Bristol Crown Court on a daily basis. He will know certainly know Mr. Ford, and probably know a lot of the officers. I was then interviewed. I then obviously couldn't provide the identity of another solicitor, an alternative to Mr. Ray. So I was interviewed through a screen by a PC Phelps or Phipps, and I'm not going to play you that. It's disgusting. I'm effectively locked in a toilet. I can't hear what this officer's saying. He can't hear me. I'm flicking these at him. I'm telling him as far as I'm concerned, not as far as I'm concerned. As far as the law's concerned, it's completely illegal. It's the statutory right, and it's coming up on your screen. It's been on your screen already earlier in the documentary. Is a statutory right. It's the will of Parliament that nobody who wants a solicitor, who wants representation, can be interviewed without the legal advice from the solicitor that has been appointed. And it is irrelevant if I can't nominate a solicitor, because it is up to the duty solicitor scheme between them and the police to facilitate legal representation, not up to the individual detainee to know a solicitor that will represent him. Bearing in mind, many detainees may not have had any, often don't have any interaction with the police at all, and then therefore wouldn't know. Why would they know the name of a solicitor, a criminal solicitor to represent their interests? It's of course utterly corrupt nonsense. But anyway, so we'll look at the exchanges between myself and Mr. Nelson. There's an email the 13th of January 22, in which he states, thank you for your email. He says to me, this is his email, as I say, of 13th of January 22. Thank you for your email dated the 28th of December 2021. We apologise for the delay in replying to you. You ask why this firm was unable to represent you at Patchway Police Station on 30th of November 21. Following being contacted by the duty solicitor scheme, this firm duly made contact with the police station. It had come to the solicitor's attention that there had previously been a situation whereby that solicitor could no longer represent you. The solicitor on call at the time therefore followed correct channels and passed the matter back to the duty scheme in order for suitable representation to be arranged. Well, of course, no suitable representation was arranged. So that Mr. Nelson knew that was a complete lie from the outset. But he states clearly that the reason that I wasn't represented was because of some past history between myself and Mr. Ray, putting it neutrally, nothing to do with my conduct on the tannoy when I spoke to him in front of Custody Officer Daly at around 7 that evening. He then emailed me again when I pursued the matter with him on the 21st of March 2023. And he stated, "Dear Mr. Gray, we write in response to your letter received on the 14th of March 2023, dated the 8th of March 2023. I have reviewed the custody record in regard to your arrest on the 30th of November 2021. I can confirm that Mr. Ray did accept the duty solicitor call and was put through to give you initial advice prior to an interview. It is recorded on the custody record that you were rude and abusive and threatening towards Mr. Ray." Well, let's pause there before we come back to the rest of the email. Well, we've seen the custody record. There's no further custody record out there, or other part that I haven't included about my exchanges at around 7 p.m. With Mr. Ray in front of Daly. Daly gives no statement that I had been threatening or abusive to him. He's merely stated I've shouted and complained that I couldn't hear who I was speaking to, or couldn't hear the exchanges between myself and Mr. Ray. So we have a solicitor. The extent of venality and cowardly corruption in coming from this man's, effectively from his mouth. Stating that I had been abusive and threatening, effectively incriminating me, because of course if I've been threatening and abusive to my solicitor, that would be justification for the solicitor withdrawing, and it incriminates me as part of the general case against me that may or may not end up in the criminal court in due course, because of course if I'm being accused of being violent and abusive or certainly abusive to Mr. Ford, to the security guard Ford, who of course Mr. Nelson will know because he's frequently attending Bristol Crown Court, and of course assaulting and being violent towards officers, then it helps their case, the CPS's and the police's case, if I've got my own solicitor, and Mr. Ray was at the time my solicitor at 7 p.m, stating that I've actually been abusive and threatening to him, even when the custody officer who's listening in on the conversation, which he shouldn't be in any event, but leaving aside the confidentiality, has given no indication that I've been abusive or threatening. So this is Mr. Nelson's fabricated evidence, effectively, if it was on oath, perverting justice, claiming that I've been abusive and threatening to somebody who doesn't actually say so from his own mouth. It's Mr. Nelson representing Mr. Ray, effectively, even when the custody officer who had more interest in Mr. Who had interest in Mr. Ray fabricating the abusive and threatening allegation, who makes no such suggestion and would have clearly done so if I had been abusive or threatening, bearing in mind there's no recording of my exchanges with Mr. Ray, so he can say anything he likes about my conduct. And it goes on, the email of the 21st of March from Mr. Nelson. It was after this initial contact with you that Mr. Ray became aware that, in fact, you had previously been threatening and abusive and rude towards him in the past, and therefore he was within his rights to hand the matter back to the duty solicitor scheme in order for you to receive further representation whilst at the police station. Thereafter, our firm had no further dealings with you, and it is clear from the custody record you were offered the opportunity of an alternative solicitor to represent you if you wanted it. I hope this clarifies the matter. Yours faithfully, Nelson Legal. He doesn't even put his own name. He just he's calling himself Nelson Legal rather than Mr. Giles Nelson, which is his actual name. In the same way, he's dehumanizing again, the same as I'm a detained person rather than Ben Gray in custody from the police standpoint. And from his point of view, he's no longer Mr. Nelson. He's the firm. He's a whole organization which just happens to be in his name. So he doesn't even identify himself, and it could, of course, I wasn't there when the email was sent. It could have been sent by Mr. Ray, for all we know, or indeed they could have got the police, maybe Police Sergeant Harris to have knocked it out. But in any case, Mr. Nelson states clearly that it was after the initial contact at 7 p.m. that Mr. Ray suddenly had this is the same Ben Gray that I've had dealings with at some unknown point in the time, in which yet another allegation of my being abusive and threatening, which wasn't recorded and can't be proven, and there's no record and Mr. Ray has no memory of, occurred. If that's the case, why did Mr. Ray take 4 hours to then contact, at least 4 hours, we'll get the exact time at some point from the duty solicitor scheme, but several hours after he's decided that he knew who I was and wasn't going to represent me. Indeed, the custody record, as we've seen earlier on from a moment ago, stating that this is at midnight, so this is actually 5 hours after the initial phone call when Mr. Nelson says Mr. Ray decided not to act for me. Mr. Ray Nelson's legal has stated he will not attend. Mr. Ray Nelson legal has stated he will not attend for interview, but will deal with it via Teams if detainee wishes him to. So he's still carried on representing me, having established that he's not going to represent me because he knows me from a previous matter. So, apart from anything else, in more recent time, after my conviction, indeed, at Gloucester Crown Court, I chased up the conduct of Mr. Ray and Mr. Nelson with the Solicitors Regulation Authority. The Solicitors Regulation Authority are the body that's set up to oversee the conduct of solicitors and how they treat members of the public, mainly their clients, but sometimes in other respects as well. And they have to ensure that the codes of conduct as set down by the Solicitors Regulator Authority are properly enforced. Well, who works at the SRA to enforce that solicitors are acting properly? Well, for a start, they're funded by the solicitors themselves. The solicitors effectively pay a sort of a certain amount every month or every year out of their wages, out of the money they get from representing their clients, most of whom are obviously on legal aid. So it's public money effectively being given to this unknown body called the SRA, where people who work there, I can't trace any of the people involved in the complaints that I make about solicitors are untraceable on the internet. They have no qualifications by and large. They're not solicitors themselves, and they are just simply the lapdogs and the puppies of, in the same way that the solicitors are the lapdogs of the corrupt police and the corrupt CPS, precisely the same way the SRA employees are the lickspittles and servants of the solicitors, and will lie. They will say any lie, any rubbish. They will collude in order to exonerate any complaint against misconduct of a solicitor. Of course, solicitors are required that they have basic requirements under the code that are very simple and straightforward. They're not very complicated, because obviously the public have to understand, what they mean if they want to make a report against the SRA. And it's not the complainant, such as myself, isn't a personal complainant. So it's not that there's another organisation called the Legal Ombudsman, and they can actually award compensation to those who they think haven't to clients who haven't been properly represented by their barrister or solicitor. But the SRA just deal with enforcement of the code, so they're effectively like a little mini police, policing the conduct of the solicitors for the general good, not just for the personal benefit or interest of a client. And of course, one of the main areas of the code is do not attempt to mislead your clients or others. That's under section 1.4 of the code. And they're obviously required to act with honesty and integrity. Those are clear-cut codes which citizens have to comply with. So, as I say, the SRA investigator in this case was a Miss Harpreet Aujla, and the letter will come up on the screen in a moment. And of course, I'm not going to read out the whole letter. I'll just deal with how she's dealt with the two main complaints about the fabrications and basis from Mr. Nelson about why Mr. Ray hung me out to dry when I was the alleged victim of kidnap and false imprisonment by the complainants, the police. She states part 2 or point 2 of the fruits of her investigation. You say Mr. Ray fabricated that you had been abusive and threatening to him, and that he refused to act for you. The custody record confirms that you were hostile towards detention officers and the police whilst in detention. Well, of course, just on that point, I mean, hopefully you don't need to spell it out, but what on earth is anybody doing relying on the custody record? This is hearsay, unproven in any court. None of these custody officers, bar Mr. Bradshaw, the complainant, was called to give evidence, apart from Mr. Bradshaw in terms of the splashing of water. But of course, the whole point about having solicitors is they're supposed to question and interrogate the veracity of what police and officers connected to the police are saying, especially if they're incriminating or defamatory and hostile towards a particular detainee. So it's a complete madness that Miss Alger is relying on what the custody record says, as if, of course, it's indisputable. What would be indisputable, of course, if it was recorded and verbally recorded exchanges such as that, the CCTV, because the CCTV at police stations, certainly in the custody area, includes sound recording as well as visual recording, which is, of course, why the evidence of my being sexually assaulted and assaulted by Bartle disappeared, the CCTV from that area. But that presumably this conversation with Mr. Ray that I had whilst I was initially speaking to him would have been recorded on the CCTV, which would have been irrefutable. We would have known what actually occurred, rather than a note put by a man who has every single interest, Mr. Daly, or it could be Miss Daly, has every interest in stitching me up, especially as I allege, and I think I've proven beyond doubt, they were falsely imprisoning me at the time I was having this conversation with Mr. Ray. And of course, at the highest, I don't know who Mr. Ray is. If I'm in custody, I've already been in a brightly lit, horrible, degrading, terrifying cell by police officers that have been repeatedly found to have falsely imprisoned and assaulted me, and I got this booming voice coming through a tannoy claiming that he's my solicitor, and then expecting me to exchange details about my case in that context, even if I could properly hear him. That is no way to carry on. But anyway, the letter goes on. It also refers to your behaviour with Mr. Ray during the intercom meeting. It may help if I explain. The firm has a duty to its staff. The firm explained there was a risk assessment made by Mr. Ray that it would be dangerous for him to attend the police station. Well, so far, we've got nothing to do with the fabricated evidence that I was abusive and threatening. The custody record is my evidence. I mean, the evil and preposterous nature of Miss Alger's determination is on the one hand to rely on the custody record where it's accusing me of shouting and being hostile, although it doesn't actually say hostile, but the shouting bit, assuming that denotes hostility. So she's happy to rely on the custody record where it helps to vindicate Mr. Ray and Mr. Nelson, but she ignores the entire basis of my complaint, that the custody record makes it clear there's no suggestion I threatened him or was abusive to him. I mean, shouting is not by itself, even if it's unjustified shouting, necessarily abuse. Even if you ignore the fact I'm on a tannoy, I don't know who this man is, and so forth. The risk assessment is whether or not Mr. Ray turned up. It's got nothing to do with the fabrication issue about threatening and abusive. This would have put Mr. Ray at a risk of harm. The custody record, well, of course, that's the same with, I mean, I've already covered that earlier, because that applies to every client, of virtually every client that is arrested. That's why they've been arrested, because they've been accused of some form of violence, usually. Of course, there are other forms of crime, but the most serious ones, or the most usual workaday ones, if I could put it that way, are the violent accusations. The custody record states you would initially refuse to have a solicitor, blah, blah, blah. I'll put the rest of the letter on the screen, but you'll see nowhere does Miss Alger actually address the fabricated nonsense by Mr. Ray, by Mr. Nelson, that I had been threatening and abusive to him. Not simply the fabricated allegation itself, but the allegation, the assertion that it was in the custody record that I'd been threatening and abusive. But of course, God help every single detainee if misconduct of their solicitor is weighed in the balance or judged based on the custody record of an unqualified, not even a police officer, but a custody officer. But anyway, there's the rest of the letter, the rest of Miss Alger dealing with point 3, which is she deals with point 2. She deals with point 2 by simply not addressing the smoking gun, which is the custody record's own record, that I have not abused or abused or threatened Mr. Ray, and Mr. Nelson relying on the custody record to say that I had threatened and abused it. We come on to part 3, to when Miss Alger deals with this concern. Mr. Ray refused to act for you, claiming he remembered you had previously been abusive to him. Mr. Ray did not provide you with details of his allegation. Mr. Ray was still acting for you. This is what Mr. Audler goes on to say. Mr. Ray was still acting for you and interviewed you, but then decided he could not act for you due to a conflict of interest. You state Mr. Ray and the police were working together to prevent you from receiving representation. You provided Mr. Ray with a DSS record, that's duty solicitor scheme she's referring to there, which does not, which will come up in a moment, and I've shown you a bit earlier as well, which does not give a reason as to why the police had cancelled Mr. Ray's replacement. The firm state Mr. Ray confirms you were extremely abusive to him many years ago when he represented you at Palmer Ray Solicitors. Mr. Ray cannot provide the exact details as the firm is now shut down. Well, you don't have to provide the exact details. You can provide any details. That's part of my complaint. If somebody's been abusive to you, so that to the extent that you remembered it many years later, and then have decided to leave them out, hanging them out to dry in a police station in the circumstances where I'm in the police station, then you're surely going to remember something about the abuse. Whether it's words, and of course threatening can mean anything. Threatening him with legal action, threatening to see him down, see him in a darkened alley. There's many types of threat, especially where the law is concerned. Threatening to harass him, threatening to put stuff online about what a crook, a venal, evil, wicked traitor, effectively, because that's what all these solicitors and judges are. They're utter traitors to the essence of what it is to have a fair and just and properly accountable justice system. But I won't blather on about that because it's obvious. Mr. Ray cannot provide the exact. The firm confirmed Mr. Ray had not become aware of any conflict of interest. Well, that's not, it doesn't have to be confirm it. That's why Mr. Nelson effectively says Mr. Ray withdrew. I mean, the fact that I'd abused, I'm sure solicitors have been abused by clients and they carry on acting for them. In my case, Mr. Ray couldn't even remember what I'd done that qualified, even if obviously it's complete fictional anyway, as just as the allegation. You know, if Mr. Nelson is going to fabricate the fact that that there's a custody record that doesn't exist, stating that I've threatened and abused him when there's no such custody record, he's clearly it's almost certainly that Mr. Ray's confected the threat anyway. I'm just talking not from my point of view. I know I didn't threaten him, but of course from the point of view of Miss Audler and Mr. Nelson. The firm confirmed Mr. Ray had not become aware of any conflict of interest. As I said, that's not only not true, but when did Mr. Ray decide he wasn't going to act for me? Because he was, according to the custody record, which Miss Audler and Mr. Nelson put so much faith in terms of trusting what the custody officers are saying, the custody record says that Mr. Ray was still agreeing to act for me, albeit not by physically attending the police station, after midnight. So that's 5 hours after Mr. Nelson, in his earlier correspondence, says that in the initial contact, he decided that he remembered me from an earlier time and wasn't going to represent me. So my complaint here is that what Mr. Ray is doing, he's depriving me of any chance of any further representation by keeping me in custody, acting as my solicitor when he's already decided he's not going to act as my solicitor for another 5 hours, so that the police have to decide to interview me or release me. They have to do that within 24 hours, but within the 24-hour period, they have to detain someone to complete an investigation, unless it's murder or something, in which case they can go back to the court and ask for an extension. But the initial 24 period it still means that they have to do things expeditiously within the 24 and not simply drag it out for 24 hours. To torture or to potentially be falsely imprisoning the detainee for that time. Of course, they have in the past done that for days. They could detain me for Section 5 non-imprisonable for 3 days. But obviously they're trying to comply, especially if they want something to go before a jury. And of course, they don't know that they're going to get Judge Lawrie, the biggest crony and police puppet, probably in the UK, I should imagine, as we shall see from the trial, if I haven't already convinced you of that. But in any event, the firm confirmed Mr. Gray had not become aware of any conflict. Mr. Ray did not attend the police station due to your behaviour. So Miss Audler, who I've never met, has no evidence, has not examined any of the CCTV of me being prodded and poked, my testicles touched by Mr. Bartle, my injury touched by Mr. Bartle, the legalities of my detention at all under breach of the peace, my initial detention, my complaint of sexual assault, but from DS Bail. And yet she's talking about my behaviour as if she herself has witnessed everything that's gone on, most of which, the recording that I myself sought from Judge Lawrie and from Judge Recorder Sellers, such as the CCTV of my behaviour, has been denied me. And then this lady who wouldn't even look at the footage anyway is talking about my behaviour, effectively recounting just regurgitating what the custody record says by the complainant, Mr. Bradshaw and others, all of whom may or may not, as far as Mr. Adler is concerned, be falsely imprisoning, kidnapping and torturing me in the process, and fear of violence towards him. That's not the reason Mr. Nelson gave. Mr. Nelson he states it clearly in his correspondence that Miss Aujla did have before her, that Mr. Nelson is not going to represent me because of my Mr. Ray is not going to represent me because of my previous threats towards him at some earlier occasion. In terms of fear of violence, well, and of course, as I've already said, that would apply to any detainee on any basis. There's certainly no suggestion in the custody record that I offered violence or threatened him in any way, not even with complaining to the SRA or to the legal ombudsman. Aujla goes on to say in her letter, still dealing with point 3, Mr. Ray had offered to assist you via Teams. Teams is the communication system that's I think probably includes sort of Skyping type interaction on videos, monitors. As far as I understand it, that's what's referred to. Of course, I'm a layman. I can't necessarily know what Teams is, but that's not explained to me either by Mr. Nelson or Miss Aujla. But she goes on to say, but you were insistent that your solicitor should attend. Therefore, at 23:17, Mr. Ray advised he would not be representing you and that another duty solicitor would be provided. Well, that's of course Miss Aujla completely ignoring the fact that Mr. Mr. Nelson had said that Mr. Ray wasn't going to represent me because I threatened him at some point in the past. He's absolutely crystal clear that is the reason. He says it in different terms in terms of his first email and his second email, but both the emails together make it expressly clear that he was not going to represent me because of the historical threats to him, not because of my conduct, even if I did threaten him on the day, which of course the custody record proves I didn't, but because of my previous misconduct to him. And indeed, that's when, after the initial conduct, he became aware of the thing. He said, what does he say? It was after this initial contact with you, Mr. Ray became aware that in fact you had previously been threatening and abusive towards him in the past and therefore was within his rights to hand the matter back to a solicitor. So he says absolutely clearly, whatever time it was, it's implied there by Mr. Nelson, it was in the initial, after the initial contact, which was the phone call at 7 o'clock, he decides he's going to hand the matter back and not represent me. So Miss Aujla is lying and lying and lying and lying and lying. She then says that it's because Mr. Ray was going to continue to act for me, but he was going to act for me hands off via a computer screen and not attend, even if I was complaining that I was being tortured and abused by the police, as the custody record certainly indicates, and was certainly the basis of my defence in terms of my conduct or alleged conduct whilst in custody. So Miss Aujla is absolutely happy. Instead of investigating the complaints, the evidence that Mr. Nelson is lying and lying and lying, and that Mr. Ray not only Mr. Nelson's openly candid, and Mr. Ray decided he wasn't going to act for you around 7 after initial contact because of the historical issue about threats. Then the custody record proving that Mr. Ray, and indeed the contact Mr. Ray made with the duty solicitor scheme, just simply carries on acting for me, even though long after Mr. Nelson has said he decided not to act for me. and then withdraw the case, then withdraw representation after midnight, when of course Harris decides he's going to refuse to allow me to have my statute right to advice, and because I can't nominate a solicitor off the top of my head, he's going to carry on interviewing me without it. And of course, Harris could only have done that on two bases. One, that Mr. Ray just continued to pretend to act for me, even though he'd made a decision, according to Mr. Nelson, hours before that he wasn't going to act for me. And then by the DSS, because the DSS note states that the police, after Mr. Ray said that Mr. Ray had handed the case back, the police call the DSS and say a solicitor wasn't required. So the only reason that they've done that is because Mr. Ray has allowed them to, having given them hours and hours of time pretending to represent me when he's already decided he's not going to, assuming he ever was, assuming he didn't know who Ben Gray was even before he rang up the police station to have me patched through to my cell. So the whole thing was engineered by between Mr. Ray and Mr. Nelson, Mr. Ray and Police Sergeant Harris, bearing in mind that Harris is then claiming that he's going to force me to the interview without representation or without advice, which you couldn't have done unless Mr. Ray had acquiesced to because there's no interest to Mr. Nelson, is it? That even the custody record proves that it was the police who cancelled his replacement. Mr. Nelson County says that Ray did all he could to ensure that you had a replacement to himself once he withdrew. He didn't, because within minutes, whatever the exact time sequence was, within a few minutes of Mr. Ray withdrawing, the police were then able to then contact the police and say, contact the duty solicitor scheme to say a solicitor was no longer required. So Miss Algler has actually trebled the amount of lies that I was complaining about to Miss Algler in order to vindicate Mr. Nelson. And of course, all of this conduct must amount to misconduct in public or misconduct in public office and perverting justice. The whole point of all the conduct of both Mr. Nelson, Mr. Ray, the police officers, and Miss Algler is just to simply make sure that I have no access to independent legal representation. So that's dealing with Miss Algler, Mr. Nelson, and Mr. Ray. And of course, in the appeal, when we come to my appeal stage, or the trial and appeal, it'll be revisited a little bit, because of course the issue about my representation was to the fore when this matter was transferred by orders of Judge Peter Blair, KC, to transfer the case to down the road to Gloucester. So the final part of this bit of before we come on to the witness statements and the glaring perjury in that, and if you're not already sick to death of the lies that you've heard already, then you'll hopefully stick with me to the end of this to part 2 of my Barbarians at the Gate documentary. So we'll deal with the MG5. The MG5 is a document that is drawn up by the police that brings together the various bits of evidence that they've got to build a case against the detainee, in my case myself. And it will list bits of key evidence such as CCTV and so forth, and it's what will be looked at first of all by the CPS and by the judge as the first port of call in terms of whether there's a case to go to trial or whether he can be picked apart by a solicitor and barrister and have the matter dismissed there and then. So what does the MG5 state? Well, it's coming up on your screen here. Summary, part 1, and it's done in different stages, box 1, 2, 3, etc. Part 1, summary of key evidence. Key evidence, it explains, establishes every element of the offence and that the defendant committed the offence with the necessary criminal intent. There's a couple of bullet points there. It says, set up the facts in chronological order, and covering the points to prove, and the summary must be balanced and fair. This is a case. We then go on to the summary as set down by the officers. Now, who are the officers? Just quickly, we're dealing with Officer Phelps, and the officer to bear in mind most of all is Tayyab Hussain, who was certainly until recently the police sergeant in charge of this case, and he has overall conduct of what goes in the MG5 and what then gets put before the CPS as a case to answer. So I'll deal with it as Mr. Tayyab Hussain, or Mr. P.S. Hussain, who's drawn up this document, than any other person. This is a case of racially aggravated public order section 4A by beating and assault by beating of an emergency worker ×5. And then the summary goes on to say, on 30th of 11/21 at 11, Benjamin Gray entered Bristol Crown Court, Small Street, and was going in and out of the building. At 12:38 hours, the defendant persisted to film staff and the security manager Henderson Ford politely asked to leave, and he replied by saying, make me, and became verbally abusive, calling him, quotation, Idi Amin, you people, and our people have died for people like you being here in this country. He continued to film Ford and was pointing this closely to his face. Ford went into the CCTV room and asked another security officer to ask for police officers to attend. Announcement went out in Crown Court for any police officers to make their way to reception area. Well, let's just deal with that and just deal with those bits and pieces just off the cuff. Well, did Henderson Ford politely ask me to leave the building? Well, we've seen him. The film footage clearly shows, even bearing in mind that at this stage no one had examined the GoPro, which proved exactly who had said what, bearing in mind that chunks of the CCTV from the court were never disclosed, the earlier bits of my exchanges with Mr. Ford, there's no question in anybody's mind that this man is abusing me, and certainly in any event, even if there's some argument that he wasn't assaulting me, that he wasn't committing a criminal offence of harassment and fear of violence and therefore an assault, he's not being polite, is he? There's no question. You don't politely tell people to move on and let's have a comedy show and coming into their face and invading their space and pushing them backwards through the door. And so forth, and complete fabrication based on what? There's no mention of the CCTV or what the CCTV shows. It was Mr. Ford whose voice can be heard calling the police. It wasn't another security guard. What verbal abuse? The verbal abuse of Idi Amin is obviously contextual. It's not verbal abuse if somebody's behaving like a tyrant and behaving like somebody like Idi Amin. There's no explanation as to why it's racist. If obviously we know about familiar words that are racist, such as the N-word and so on and so forth. I'm not going to list them here because that wouldn't do me any favors, but I grew up in the 70s and 80s. They were part of common day speech in those times, and those are words we understand and know to be racist. They have connotations and implications from colonialism and slavery and so forth. But Idi Amin is simply a well-known dictator who happens to be black. It can't seriously be suggested. We haven't yet surely reached the stage where only white tyrants are allowed to be mentioned when complaining about the conduct of white or black people. If somebody's behaving like a Napoleon, they're behaving like a Napoleon, whether they're black or white. If somebody's behaving like an Idi Amin, who is just another equivalent of a Napoleon or Hitler, why on earth can't we use that expression? It's not racist by itself to call someone Idi Amin. It may be if you see a person of colour and just randomly shout out that they're Idi Amin. Even in that context, I can't necessarily see that it's necessary. You have to be quite a strong argument to prove that it was racially aggravated or even an offence already, because you obviously have to have an offence before you have the racially aggravated offence. And of course, what this summary misses out is it not only misses out but lies about is Mr. Ford's conduct towards me, because however I respond, whether it's with words or violence, it's in response to Mr. Ford engaging with me and then assaulting and attacking me. It's not. I'm not there to even speak to Mr. Ford. I made it clear I want to engage with Mr. Groves, who has no objection to speaking to me, so it's just a simple fabrication. Hopefully, because you've seen the footage, you don't need it spelt out. We then go on. Of course, the key issue is evidence. Now the police have sinisterly and wickedly deprived me of legal representation, in cahoots with Mr. Nelson and Mr. Ray's endless, almost lunatic lying, casual lying on every single issue surrounding that. The police are then free to get rid of any evidence and pervert justice and do anything they like in order to then get a case to put forward, because the only objective at this stage, which is their objective generally, is to shut me up, because here I am online with all these revelations about the extent of sort of, tin pot dictatorship style corruption, and that has been their intention, and all the cases surround that will be part of other documentaries are all basically around their general intention to terrorize and shut me up and stop me being at large, so that I can let the public know quite to what extent they are under they are ruled by utterly corrupt and venal and deeply dangerous and sinister individuals from top to bottom. I'm not saying this applies to every judge or every area in England and Wales, but certainly where the Bristol judiciary and police are concerned, the Bristol CPS judiciary, and the few High Court judges involved in that, then this is like a mini state within a state, effectively, if it isn't sort of the everyday world of other individuals in other areas. But coming on to the visually recorded evidence, this is key, because obviously nowadays so many incidents are recorded in some way or another. There's some sort of technical digital imprint on the mobile phones, cameras, blah blah, and so obviously this is now included in the MG5s as a standard practice. The CCTV, visually recorded evidence, this is part 4 of the MG5. CCTV, photos, mobile phones, attach a copy, identify playback format. Custody suite CCTV should be included as unused material unless key evidence. Is there VRE, video recorded equipment? If yes, key evidence, yes. Give details of what it shows, whether key or not, and include tape counter reference times for relevant key sections, brackets, i.e. defendant punching victim, kicking window, close brackets. For ABE interviews, ensure that the witness name and length of the interview are included in the description. Well, I have to profess ignorance. I don't know what ABE is, but it's just talking about interviews with, I think, other witnesses other than the suspect. And of course, you'll notice that the suspect is referred to as a defendant in the MG5 because it's already been decided. Therefore, it's supposed to be fair. It includes the word fair in its introduction as to how the police should conduct this, should fill in the form. But the fairness doesn't include actually considering whether the suspect is actually innocent and the victim, because he's already called the defendant, or he or she. But it goes on to say, inside, this is what the officers then fill in as to what's actually, what video evidence is available. Inside shows footage of main foyer showing Gray appearing at 12:38, interacting with victim Ford and exiting through the main entrance at 12:56. Outside shows main entrance punching DS Bell at 12:57 and spitting at the officers detaining him. Well, where is any mention of the GoPro? The GoPro is the sound recording, so it includes what words are said by both me and Mr. Ford and in what order. And of course, there's no mention of that. They should include the existence of it, even if they're not going to open it up or rely upon it. And we should come on to a statement by Joshua Stevens. In any event, here he is claiming, you'll see later on that he claimed that he just simply packaged up the SD card that was inside my GoPro and sent it off. I'm there for a prompt and effective investigation. The sound recording and the video evidence is obviously the most pivotal evidence that could possibly influence an investigation, and that is completely ignored both in the summary of what evidence is available in the MG5 and it's not even looked at until by the police and CPS until weeks and weeks after, notwithstanding I'm complaining that I've been the victim of assault from Ford. So the inside, where the officer refers to where Tayyip Hussein, because he's made this report, inside shows footage of main foyer showing Gray appearing at 12:38. Well, what happened to the first 10 minutes? Because you can see the timestamp, and that's the timestamp that was given to me on the footage that was given to be my Miss Constable, the CPS representative from Devon Chambers. You can see quite clearly that the first 10 minutes, even though it was viewed initially in the MG5, vanishes in a puff of smoke. It is an officer has literally sat there, presumably it's Joshua Stevens or maybe another, maybe even a CPS officer, has sat there and edited the footage that I'm going to get given and then is going to be shown to the jury to exclude the key evidence that proves that Ford is attacking me. We can see that he's attacking me, and we can hear it from the GoPro that was disclosed. And I think the first few minutes of the GoPro is missing, or it's rearranged. I'm not entirely sure because it was a long time ago and quite a traumatic incident. So the order of events may be a little bit confused, but that's where the footage helps. And certainly the CCTV, which is the sound, not sound recorded, but it is from the bird's eye position that shows exactly who's standing where and who's, if there's ever any evidence of physical assault, it will be shown clearly on the high definition CCTV. But what good is that if the police don't disclose it? Because they haven't disclosed it, because even from the close-up footage of the GoPro, we can see that it is Ford who is the assailant. He's attacking me, he's chiding me, he's goading me, he's ordering me to leave when I'm committing, not explaining about what powers he has or what law he has, and clearly he has to use reasonable force if he does have such powers, but there's nothing that I'm doing that creates anything near the sort of conduct that would amount to him using his powers under Section 53 that we discussed in part one. But because the police and the CPS know that Ford is the attacker and the assailant, and that I'm simply responding, when I call him Idi Amin, I'm responding to the fact that he's assaulting me, is neither here nor there. Is because I'm the victim of the assault. That's why it has to be excluded. So just before we finish off on this stage of part one, the next stage will just deal with the witness statements before we come on to part three, which deals with the trial and appeal. Just a brief couple of points about the MG5 document. Well, we can see the statement by Mr. Hussein, Police Sergeant Tayyip Hussein. He states that Mr. Ford had complained, and he does in his witness statement, you people and our, just going back to the Idi Amin point, he goes on to say, you people and our people have died for people like you being here in this country, full stop. I never said that. You can hear the recording. The recording is identical to, well, it is the recording, so it's indisputable. The sound recording, of course, which wasn't played or wasn't listened to, or was listened to by the police, but then was carted off as if they hadn't listened to it, clearly proves that I said no such thing. When I'm talking about dying for getting onto the patriotic element of my speech in relation to Ford's conduct, I'm talking about the overall corruption of the judiciary, and I clearly say every corrupt judge, every corrupt police officer spits on the cenotaph, effectively, metaphorically speaking, is what I'm saying there. I've got it's nothing to do with race or our people in terms of the difference of races involved in all walks of life, including the police, including the judiciary and the CPS and so on and so forth. It's got nothing to do with apart from the fact that Mr. Ford's conduct is indicative of the general corruption that oozes out of Bristol Crown Court in the same way slime oozes out of a slug, and that the conduct of Mr. Ford, as I make clear, and as palpably obvious, I should think, that Mr. Ford is simply an attack dog. He's not physically in the pay of the corrupt judges, like Judge the judges I've listed in my mission statement, who are even concerned with this case, Judge Blair and Judge Picton and so forth. He might as well be. He might as well be on their payroll, and he clearly knows me because I've been in and out of the courtroom before. I've made other complaints about his conduct, which I'm not going to bore you with because it's fairly trivial compared to and it's just symptomatic of the general corruption. But I'm talking about him in that context and not about race. And I never mentioned our people dying for your people, and this is a complete perjured fabrication, which obviously they need something to remand me off to custody. So they fabricate, they collude with Mr. Ford in progressing this fabrication, this perjured statement that I referred to your people and our people, to turn it into a racist element, so that Mr. Ford can play the race card and say it's all about Mr. Ford being black, and I've come in off the street to record myself, having won case after case in criminal proceedings, accused of everything under the sun. I've decided I'm now going to incriminate myself to the nth degree in one of the most woke country states, or mini states, as Bristol effectively is, woke areas of the Western Hemisphere, and start making racial comments about the large black male security guard, and go on about my people and your people dying and so forth. The order was not polite. He was assaulting me, and I never said in any event your people and my people as the GoPro footage, which is why it's not mentioned. So I will finish off on again referring to the criminal law as it stands in this country. Indeed, the most recent to date issue about perverting justice. Now, 2823, this is paragraph 2823 of Archbold 2022, which I've referred to in my earlier proceedings. I might even quoted this, but just for to refresh our memories in the context of the missing footage that I've talked about in the MG5. The concealment or destruction of evidence, this is the ruling of the courts and the summary of what perverting justice is when it comes to concealing evidence. The concealment or destruction of evidence relevant to an investigation is clearly an act which has a tendency to pervert an investigation by turning it from its right course. If a relevant act might mislead a court in any or all of the possible types of proceedings that might ensue, that is sufficient to justify a conviction. That's the ruling of Sinha, 1995, Crim LR 68 CA. So again, it's not brain surgery. That there's been offences of that nature going back hundreds of years of perverting justice. Any evidence that a police officer or a civilian or CPS, and obviously it must relate mostly to police officers, although not just to them, because of course police officers are the most likely to be associated, certainly with dealing with initial evidence in an investigation. So Joshua Stevens and Tayyab Hussein and Phelps have all got their little heads together, or not little heads, but obviously not of the most intelligent variety of police officer, and decided that they will just simply remove any evidence that not only vindicates me and proves that I was the victim of false allegations from Ford and from the officers, but indeed remove all the GoPro footage that proves that these officers were lying and that I was the victim of misconduct and assault. The whole chance of the incident from the CCTV was deliberately removed from the final disclosure, obviously with the collusion of, importantly, Recorder Sellers, the trial judge, but we'll come to that when we come to the trial, and of course Miss Judith Constable, the CPS rep, and the same with the GoPro, which wasn't disclosed until, or even looked at by the police until months later. And of course, by which time, when the footage had disclosed, it was of no interest to Recorder Sellers. When the matter came before trial, in fact, the footage proved I never said your people or my people, or that Mr. Ford is quite clearly attacking me in no uncertain terms, and of course endangering other members of the public into the bargain. But of course, that is for the trial procedure. But that brings us up to date in terms of the stitching up, the cobbling together of a pack of villainous and wicked lies to make me out to be the instigator, a racist, violent barbarian, me the barbarian, who has simply and understandably and justifiably resisted being detained, being kidnapped by Mr. Bale, having already been the victim of a villainous and deeply cowardly attack from Ford. Bearing in mind, Ford not only wears a uniform, he not only has backup from his other colleagues in uniform, but of course he's a very large, much larger than me person in his own right. And of course, I'm not saying boo to him when I come in. I'm here to talk to Mr. Groves in relation to matters which would be too complicated to go into in this documentary. But we'll come on next now to the witness statements. So, without further ado, ladies and gentlemen, let us look at the witness statements. Obviously, the key evidence, given that the police have no interest in the content of the footage, bar from a little bit that's taken out of entirely taken out of the context of the whole. Let's deal firstly with D.S. Bale's witness statement, which he made on the 30th of November 21, i.e. on the same day as the incident itself. Stuart Bale stated as follows: I am Detective Sergeant 3315 Stuart Bale of the Avon and Somerset Constabulary, and I am currently based at Kennethsteele House Police Station, where I work within the Major Crime Investigation Team. On Tuesday, 30th of November 2021, I was at Bristol Crown Court undertaking police duties for an unrelated matter. Due to the nature of the duties, I was in plain clothes. I did not have any handcuffs or police batons with me. At about 1 p.m. on that day, I was in an office on the first floor with Detective Inspector Roger Doxey when a tannoy was broadcast out over the court system requesting police officers attend the front entrance of the court. D.I. Doxey and I left the office and walked down to the ground floor, where I immediately saw a male stood in the holding area before the metal detectors as you enter the court. I would describe the male as white, about 6 foot 1 inch tall, of medium to large build, with short hair and glasses. He was about 45 years old. He was wearing a long-sleeved top, chino-like trousers and trainer-like shoes. I could see him holding up what looked like a small camera. He was pointing it towards the security staff and speaking in a raised voice. Inside the hallway of the court, I briefly spoke with a male whom I understand to be the head of court security, called Henderson. I have seen him many times at the court in passing. Henderson told me the male was refusing to leave, had called him Idi Amin, and was being racist towards him. Henderson is a black male. I walked with D.I. Doxey through the barriers. D.I. Doxey then spoke with the male. The male was agitated and confrontational. He was still holding the camera and pointing towards court staff and myself. D.I. Doxey asked what the issue was. He refused to engage with D.I. Doxey and remained animated by moving his arms around. I do not remember all that he said, but I recall him refusing to leave the building after several requests to step outside. At several points I asked for the male's name, and he failed to provide it. He did ask my name, and had provided my full name, rank, and collar number. I was also wearing my police lanyard around, with warrant card contained around my neck. I asked another person, who I believed to a police officer, to establish what exactly had been said to Henderson. I later spoke to the officer again and was informed again he had directed racist comments to Henderson. Due to the male's behaviour, his refusal to leave, his agitated state, and because he had directed racist comments towards Henderson, I decided to arrest the male for a breach of the peace. I said words similar to, because there has been a breach of the peace and because you are refusing to leave, I'm arresting you for a breach if the peace. I mean, that obviously means of the peace, but there's multiple spelling and grammatical mistakes throughout the statement, so that's just a taste of what's to come. I then cautioned the male, who seemed initially to calm down a little. I then informed him that I needed to search him and asked him whether he had anything on him that could harm himself or me. He turned out his pockets and placed some property on a sideboard. During the search process, he made a comment similar to "stop touching me up." He had a rucksack with him along with a phone and paperwork, which I handed to DC Simon Beaton. The male was then saying things similar to that if he calmed down, then my powers under a breach of the peace would expire. I told him I still feared he would come back to the court and cause a problem, and that it was necessary to detain him at a police station until he calmed down and there was no further threat. Meaning at some point, I asked that colleagues call for a uniform backup as I was concerned about his erratic behaviour. Diadoxy and I then persuaded the male to step outside the court. We ushered the male into an area directly to the left where some railings prevented the make running off. I think that's making off, I think is what he's saying. God knows. We continued to, there's no semblance of any understanding that what this officer is saying is impacting on my freedom, whether I get remanded, whether I get convicted, and the most great chunks of the text of the statement doesn't even make literal or grammatical sense. I again explained that he would need to be taken back to a police station. Running off. We continued to engage with the male, although he says make here, but he presumably means male, who was still animated and aggressive. I again explained that he would need to be taken back to a police station as I feared his release. Without warning, I became aware of a sharp blow to the front of my face in the mouth area. My head jolted back and I was disorientated for a second or two. The situation was confusing and fast-moving, but I remember seeing the male in front of me and it was immediately apparent to me I had been struck hard in the face by him. I feared further blows to myself. At that point, I know Diadoxy became involved in restraining the male. I cannot recollect exactly how this occurred, other than I remember we pushed the male back against the wall. I took hold of his right wrist to prevent further strikes and was leaning with my body against his to prevent him moving. Diadoxy also had hold of the left side of his body. The male became abusive. He spat directly in my face. I could feel the wet spittle land. I later learned that I had a bleeding injury to my upper lip and lower lip, which would likely have been exposed to the spittle. The male also spat out at Diadoxy. At some point, DC Richard Warren also attended and stood behind me. He helped out with the restraint of the male. Henderson also joined in and helped. He held the male around the chin area, which had the effect of preventing the male from further spitting at us. I said to the male, I am further arresting you for assaulting me. Although I do not recall recautioning him at this point. I was aware that DC Simon Beaton also joined us and was nearby. He said comments similar to that he was monitoring the male's breathing. Throughout, the male was still able to speak clearly. At one point, he asked me why he was still being restrained, to which I responded by saying that he had punched me in the face. After several minutes of holding the male, uniform office colleagues arrived. I watched as he was handcuffed in the front stack position. I then stepped away and let my uniformed colleagues deal with the male. DS Lucy Edgeworth then told me that I was bleeding from my lips and I has blood on my shirt. I think had blood is the word he was looking for there. She took a photograph of the injury to my lip. During the incident, I was also aware that a camera crew in a black van were filming events outside the court along with DS Lucy Edgeworth on her phone. I have made the statement at 15:30 on 30th of November 2021. I'm still shaken and shocked at the unexpected aggression and violence directed towards myself, my colleagues and court staff. My lips are sore, have been split, and I have a headache. I also have a soreness to my left cheekbone. I do not know how the soreness to the cheekbone occurred, but it was during the incident. I do not know the male concerned. To my knowledge, I have never met him before. Stuart Bell. Well, it's almost impossible to know where to start with that litany of utter filthy lies and corruption and whitewash. The issue about the grounds of my arrest is so simple a child could understand it. It's made simple because there have been so many rulings about whether or not police and civilians, because civilians also have the power to arrest under breach of the peace, can arrest under particular circumstances. Officers can arrest, and civilians can arrest somebody if there's violence or threatened violence. That is the High Court ruling of people much wiser, much more learned than Bale or myself, that have clarified for the sake of any potential further civil proceedings against the police what powers the police have to arrest for breach of the peace. Bearing in mind, although civilians have that power, it's mainly used by police. And it has to be, under the ruling of Lord Board, it has to involve violence or threatened violence. There is not a shred or single iota of evidence provided by Bale himself, let alone on the footage, but Bale's description of my being agitated or refusing to leave a public building, none of them amount to violence or threatened violence. He does have powers, or police and civilians have powers to arrest for breach of the peace to prevent a breach of the peace, not because a breach of the peace has occurred, if they're being racist, because that would potentially create violence to them, and therefore there is an issue of violence. But that's arresting to prevent a breach of the peace, not for a breach of the peace. And of course, the preventing breach of the peace has to be immediate anyway. There's going to be immediate violence, not at some distant point in the future. So Bale's own definition, he's kidnapped me. He's outlined reasons for detaining me under breach. That he's made it clear he's detaining me for a breach of the peace, bearing in mind that later on in the documentary you will see that Recorder Sellers simply fabricates the grounds because Bale himself has changed the grounds, which I wasn't focused on, because I was focused on in person on other matters, and I missed the point that Sellers had simply fabricated why Bale claimed to have arrested me, which was to prevent a breach of the peace, which is what he changed under testimony when it came to trial. But in the witness statement, in the sworn witness statement that he gave initially, he's arrested me because various points of my conduct about being agitated and having said something racist, not in front of the officer himself, but he's been told by Henderson and by somebody else anonymous has also said that I've been racist, but no specifics are provided. But even if I had been racist, that may entitle Bale to arrest me on suspicion of a racially aggravated public order offence. It doesn't entitle him to arrest me because I've committed a breach of the peace, because the conduct has to be in front of the officer. And he's not arrested me to prevent a breach of the peace, which would be the grounds for arresting because somebody's been racist. The breach of the violence or threatened violence is non-existent in terms of anything to do with my conduct, and that's the first point. And then we go on to no mention of my clearly stated complaint against Ford, that Ford has assaulted me, and he's the villain of the piece, he's the culprit, he's the assailant, not myself, and all my behaviour that is described by Bale is completely out of context to my being. Of course I'm going to be agitated if I've been assaulted by a security guard that's supposed to be preserving, securing, making me secure as well as anybody else, but instead of making me secure, he's abusing his power and trust by assaulting me in a completely deranged and lunatic way, saying he wants to create a comedy show. And of course, the more upset I'm getting, the more he's winding me up, saying, fill your boots and so forth. I'm complaining about corruption in the courts and how these corrupt, horrible, lying, villainous judges are effectively spitting on the cenotaph and making a mockery of all the sacrifices by those who fell in two great wars and many other battles for the basic rights that are supposed to be enshrined in a British court building. And he's saying, fill your boots. He's saying that's fine as far as he's concerned, for judges to act, to spit on the cenotaph metaphorically or literally or whatever. And But in any way, the key point is that because my complaint of being the victim of assault from Ford, and therefore my complaint against the officers for treating me as the culprit, is completely whitewashed from the witness statement. That's not just simply perjury, because perjury can be by omission, but it's perverting justice. He's concealing the offence that clearly occurred, because the film bore it out, just as the CCTV that was never disclosed of the incident was also concealing the commission of offence. He's trying to build a case that he's trying to portray me as wildly attending the court for no other business than to racially abuse poor Mr. Ford. There's no complaint from me mentioned anywhere that I've been the victim of assault from him, and this is why I'm likely to be agitated from the assault from him, and then twice even more agitated by being surrounded by masked weirdos, which they are, quite weird characters by masked men. And treated as though I've just murdered one of their relatives. That is the level of egregious lies that Mr. Bale is stooping to, and he knows it's all going to be colluded with by the CPS and by the puppet judges, the corrupt jokes such as Judge Lawrie and Judge the judge who in whose building this incident has occurred. He states that I refused to engage with DI Doxy, now Detective Superintendent Doxy, but at the time mere Detective Inspector Doxy. Utter lies. I'm saying I'm happy to discuss the matter with you. I'm calmly indicating that I want to talk about or make the complaint about Ford's behaviour. I'm simply saying that there's no lawful basis for them to demand that I am removed or remove myself from the court building. It is much my building as it is anybody else's in that building, so it's just more utter fabrication from Bale in his sworn witness statement. The grounds for detaining me in terms of his refusal to allow me to leave when I'm clearly not. I've calmed down. I'm outside the building now. I'm not engaging with Ford anymore. I'm not being agitated. I'm not being whatever else it is. He says is causing me to be deprived of my liberty. And he states I feared. He says I again explained that he would need to be taken back to a police station as I feared his release. That's not a even if the fact that the officer fears my release, he probably by now fears that I'm going to complain about him as a sexual molester and a kidnapper. So he would obviously want to fear my release, but that is not justification for detaining and locking somebody in a toilet in a police station. And we have Lucy Edgeworth's DS Lucy Edgeworth witness statement, and she stated on the following day, the 1st of December 21. I am Detective Sergeant 581 Edgeworth of the Avon and Somerset Constabulary. On the 30th of November, I was on duty in plain clothes in Bristol Crown Court when I heard a transmission for any police officers to attend the foyer. I made my way to the foyer and saw a male I now know to be Benjamin Gray, who was being arrested by DS Bale for a breach of the peace. I was not party to the lead up to this. Due to the male's behaviour, I called for uniform response to assist us in removing him to custody. DS Bale and DI Doxy then, I think that's supposed to say, escorted Gray outside the main court building. I followed and was in the company of DC Warren and DC Peter. I saw DS Bale turn to say something to DI Doxy, and at that point Gray punched DS Bale to the face. I heard the impact, and I saw him again attempt to punch DS Bale. I was not sure if this impacted his face. Gray was then restrained by officers, including the court security manager, Henderson Ford. He was restrained until uniformed police. I think that's supposed to say until uniformed police show up. I took images of the injury to DS Bale that I exhibit as 58.1 LE1 and 58.1 LE2. Well, at least Bale made reference to the fact that the incident was filmed by Lucy Edgeworth. She herself neglects to mention the fact that she's filmed the entire incident. Her description is from her point of view is largely accurate, but of course when she says punch to the face, that's very vague. The face is a huge area comparatively compared to the amount of places it could be punched, and you would have thought that as an experienced, trained CID officer, she would be able to sort of or know to clearly indicate where the punches occurred so that it can be verified by the footage and various statements, especially if it's disputed, which it was by me, because I totally disputed it. I neglected to mention when dealing with Bale, of course, that Bale says I punched. It's almost trivial compared to the rest of the perjury and the perverting justice, but I punch him clearly to the side of the head. That can clearly be seen on the footage. Here's some slow motion of it now. It's nowhere near his mouth. He's not even looking in the right way for me to be able to punch him in the mouth. Certainly with my right hand, as I do at the time. So, but apart from that, what doesn't she describe? She doesn't indicate me shouting halfway through the incident that whoever it is, get your nuts off my leg. Or thigh. This is a complaint that I'm making, because whilst I'm being restrained by Ford, it's not Ford who's doing it, because he's busy strangling me, but the officer to my right, whoever that is, whether that's Warren, Bale, it was never investigated, it was never pursued. But one of those officers was, whilst restraining me for no good reason, straddling my thigh, and so that I could feel the genitals being pressed against it. And I scream, and I have to do it several times because it's not responded to the first time. It simply carries on, which shows you it's glaring evidence of the extent to which it was deliberate in the first place. And only after several times of complaining are the genitals finally removed from being attached to my person or pressed against my person. But there's no mention of that complaint, just as there's no mention in Bale's statement of my complaint that I've been assaulted by Ford. And that's completely whitewashed, as is the fact that she's filmed my complaining about that assault and filmed the incident generally. And why would she not include that? Clearly, she hasn't included reference to either my complaint or the film footage of it, because she's colluding in covering up. She wants to conceal the commission of the offence in the form of the complaint about the sexual assault. It's important to stress that I didn't even pursue that particular line strenuously in court proceedings, because it was effectively concealed behind the gates and the various bodies being pressed against me. So I wouldn't have been able to prove incontrovertibly, as I was able to do with Jack Bartle, PC Jack Bartle's search of me, and DS Bale's search of me initially, that I was being sexually assaulted. I'm obviously being generally assaulted, because if I'm being falsely imprisoned, then obviously my resisting being falsely imprisoned is justified, and therefore I'm not being lawfully restrained at all at any point. But then, of course, I'm then again searched by Goering, or whoever his name is, who never gave statements before I'm put in the van. That has no lawful basis. That may have more lawful basis, because there is some evidence that I've caused harm or danger to myself or others, because I've just punched Bale in the face. But of course, I've done that because I'm being illegally restrained and sexually assaulted by him. But so for those reasons, I haven't concentrated on the nuts pressed against my leg in quotation marks, and the body search by Bale, by Goering and whoever else is dressed like the Gestapo stormtrooper. Although they did tread on my foot as well, but again, because it's not on footage, there's just no point in pursuing that particular line, given the onus being on me to prove my allegations. But obviously my point about this whole documentary and everything that I've disclosed in it is that all this is happening with full collusion, full agreement of the corrupt judges at Bristol and Gloucester and in the High Court, such as those that I've mentioned, Lord Justice Mark Warby, Lord Justice Davis, Judge Blair, what's his name? Peter Blair, KC, and Judge Ian Lawrie, and the freshly crowned judge, Judge Robin Sellers. The whole point of this is that because it's happening in broad daylight, this is simply an establishment stitch up from start to finish. The extent to which these officers may not know of me or may not have heard of me, which is quite possible, during this incident or prior to this incident, or even during giving the initial statements, is indicated by the fact that Lucy Edgeworth is obviously frightened or worried that this might go to court in some way, and certainly if it goes to London, where there might be some possibility of an independent court who will judge, who will have none of it, and indeed get the investigation going in the proper direction, which is towards the officers who are kidnapping and sexually assaulting me, and of course towards Ford, the perjurer Ford, and perjurer and thug Ford. So she's omitting any mention of the fact that she's not filming, although she's omitting the fact that she is filming, clearly in the belief or the understanding that there may be some sort of independent investigation later on, which she wants to cover up and help conceal. She's not aware of the extent to which police can do literally anything they want. There is no villainy, no form of abuse that they haven't inflicted, short of gang rape, and I touch wood, that's not on the cards at some point in the future. But there's attempted strangulations, sexual assaults, kidnappings, perjury. Literally could fill a whole room in terms of previous incidents. So it doesn't matter if Lucy Edgeworth's filming, and of course Bale doesn't mention the sexual assault with the nuts as well. You would have thought that these are CID officers. These are officers who are supposed to specialise and care about people, any civilian who has complaints that they've been the victim of, especially sexual assaults or kidnappings. Serious crime basically is what they specialise in, not carrying out specialised crime, as you'd assume from everything, including their statements, to do with this case. But it shows the extent to which they clearly must be doing the same kind of villainy and collusion in anything else they investigate. And if they're going to do it in broad daylight whilst they're being filmed, or even deny they're actually filming when they're filming and so forth, surely that indicates to you the threat these people are to the general public, rather than just because of the personal vendetta against myself. And then we have the statement from Roger Doxey, who is the senior officer present. So he's the one who's supposed to be, organising. He gave no indication that he wanted me to be arrested, even though he was the senior officer present at the scene. But we'll give a statement. I'll read out a statement, and we'll come back to that. He made this on the same day as the incident, the 30th of November 21. I'm Detective Inspector 619 Roger Doxey of the Avon and Somerset Police, currently based at Kennethsteel House Police Station. I was on plainclothes duty in relation to an ongoing trial at Bristol Crown Court when at around 1 p.m. on Tuesday 30th of November 2021 I responded to an announcement on the court tannoy system. Any available police officers please report to reception as soon as possible. I went to reception with DS 3315 Bale, and I could immediately, it's supposed to say, hear a disturbance. I heard a comment that there had been racist abuse of the security guard. I believe that this came from another security guard, but my focus was on responding to the disturbance, so I did not take details at this point. I could see that there was a male stood in the public side of the security holding area, where members of the public go through a metal detector and are searched. I don't think it's a holding area, but let's pass on. It's a reception area. Holding areas are in cells or to do with cells. I would describe him as a white male, tan skin, broad build, around 6'2" tall, wearing glasses. He was wearing trousers and a top, which I do not remember. He was around 45 to 50 years old. The male was standing on his own, holding a small white camera, which appeared to be recording. He was immediately verbally aggressive, saying, "What have I done wrong? You can't make me leave." I did not know what had occurred, so tried to keep the situation calm, asking him what the matter was. I suggested we speak outside, to which he said, "Who are you? You need to identify yourself." I told him my name and rank, and DS Bale also introduced himself. He went on, "I'm calm. You can't arrest me for a breach of the peace." He was not calm, though, and appeared to me to have quite an unpredictable manner. I explained that the court security did not wish for him to be in the building, and so he needed to leave, and that I needed to prevent a breach of the peace. He was very agitated. His face looked very angry, and his voice was raised, saying, "You can't make me leave. You can't kidnap me." DS Bale stepped in and said, "I'm arrested you for breach," I think he means arresting you for breach of the peace, and cautioned him. I asked him to step outside again, and he did do this, and so he walked into a small enclosed area at the outside of the court. Having been in plain clothes, I had no personal protective equipment, and neither did DS Bale, and so we again tried to keep him calm whilst backup arrived. I tried to keep the conversation to a minimum, as he was getting angry in response to anything said. He had said, "The breach of the peace is over now, so you can let me go," to which DS Bale explained that he feared that a breach of the peace would continue if he was not taken to a police station. The male said, "You can't keep me there forever." We stayed outside the court, and I thought that things were getting calmer. Then all of a sudden, without warning, the male punched DS Bale to the face. He did a little circular movement with both of his arms, almost like winding himself up for a punch, before he then hit DS Bale with strong force. I believe that this was his right fist, but I cannot be sure. I was shocked and took a moment to react. I was fearful of further assault, and so launched myself at the male to grab him in a bear hug position to restrain his arms from further punches. As I did this, DS Bale and other people came to our aid to help restrain the male. As I tightened my grip around the male, I started to feel pain in my right arm and upper chest. I'm recovering from a broken collarbone 5 weeks ago, and so the pressure of having to restrain the male caused me a lot of discomfort. The male then spat at DS Bail in the face. Then he spat at me right in the face too, and then he spat at the security manager in the face, who I now know to be Mr. Henderson Ford. This was disgusting behaviour, and I felt revolted at feeling his spittle across my face. It was totally unacceptable, as we had been very reasonable with him. He was shouting things at us, but my focus was on restraint, and I didn't take much notice of the words. Due to the pain I was feeling, I took the opportunity to back away, and Mr. Ford took over from me, restraining the male, along with DS Bail and DC Warren, who had arrived on the scene. The male continued to display angry and aggressive behaviour. His temper escalated and calmed continuously over the period of time until uniformed police arrived. I noticed that a camera crew were filming a lot of the disturbance, and DS Edgeworth had arrived and started to film the male's behaviour too. He appeared to be trying to get a reaction, but everyone remained calm and professional. I did not take much notice of what he was saying after his arrest, as my role changed to stepping back, keeping everything calm and ensuring that we had uniform backup. So I went to the security office to chase the progress of the 999 call. I was approached by a couple of members of the public who said they had witnessed everything, so I directed them to DS Edgeworth, who took details. I saw DS Bail immediately after the incident and saw that he had suffered a split lip and had blood on his shirt from the assault. He appeared shaken up and in shock. He was also concerned around the health implications of being spat at. I also am concerned around around any infections that may be caused by being spat at. It has now been around 2 hours since the incident took place. My arm and collarbone is in pain from this incident, and I feel dirty and degraded at being assaulted. There is no excuse for such unreasonable behaviour and assault by this male, and I am willing to attend court as necessary. The incident lasted around 20 minutes from first meeting the male until the assault and my restraining role, concluding outside the court. Visibility was clear with no obstructions. I had not met the male before, but would recognise him again. Well, there's not really too much to add to that I haven't said about Bail or Edgeworth. The initial incident, again, no mention of my complaint, just as with Bail, so they've clearly got their heads together on this. No mention of the counter complaint. Indeed, I was the initial complainant because I actually phoned the police before Henderson Ford called the police down to do his dirty work a few minutes later. So the complaint about Ford again is whitewashed. That's clearly concealing the commission of an offence. That's clearly perverting public justice and perjury on the part of Doxy. He says that he was totally reasonable with me, and it was me that was being unreasonable with him. Well, the footage proves that's complete fabrication. And there's not much more to add. It's not clear why Ford is allowed. Ford is the complainant, so Ford should already be kept distance from me because there's no dispute on the sound recording that I've complained that Ford has assaulted me, and there's obviously going to be allegations going either way. So should Ford really have been allowed to be the one restraining me after I've been arrested for my so-called conduct towards Mr. Ford, bearing in mind there's officers all over the place to do the restraining, and indeed Doxy claims that he had the matter in hand himself. But you know, that's a petty point, and of course Doxy doesn't mention anything about the complaint of sexual assault from Bail. He doesn't mention anything about the complaint of the sexual assault from whether it was Bail or one of his colleagues pressing his genitalia against my thigh. So again, concealing the commission of offence, perjury, deliberately giving the most completely fabricated version of events in order to portray me as just completely unreasonable, having turned up at the court and without any kind of justification or excuse become upset with Mr. Ford. And then he casually refers to the fact that I've refused to leave the court building, that he simply admits that he's just come up to me and said that the security staff want you to leave, which is effectively what he does. That's the nearest to the truth Doxy comes in the entire statement. and that's borne out with the footage, that he simply strolls up to me in a mask and says, well, the security staff want you to leave, therefore you have to leave. Nothing to do with the law, nothing to do with whether or not I'm the victim of assault from the security staff, nothing to do with my rights to be in the building, about just as a member of the public or for specific business that Doxy isn't slightest bit interested in knowing why I'm there in the first place. He's acting as though he owns the court, it's his building, and that anybody he doesn't want to be in the court, or he and the security staff don't want to be in the court, is supposed to hop it, as though there's any law or basis in law for that to be occur, other than that officer is committing an offence by harassing a member of the public and refusing to enforce the rights of that member of the public that he's supposed that he's sworn to protect. He talks about being degraded, and yet he's got no interest in the degrading feelings and manifestly disgusting and unpleasant feelings of having a strange man rubbing his hands all over you without any legal basis at all. Indeed, using his uniform, using his power, just like a Carrick, David Carrick, or Wayne Couzens or David Carrick, any of these monsters, because they have got a uniform and they've got a badge, then your body is theirs to do as they want. That's effectively what Dox is saying. And then but he's got no concerns about my feelings as being subject to that, even when he's lying as to surrounding the issues about detaining me or restraining me, and yet he's got no interest. Yet he's saying I'm the victim because somebody has reacted to being touched up, molested, kidnapped, and all of which he's virtually admitted to carrying out in response to that kind of abuse. So we deal finally, just before we get on to Ford, and that's the statement of Terry Groves. You'll recall that Terry Groves, from the initial engagement when I first arrived at the court building, is I'm trying to speak to him. That was the purpose of my visit, about his testimony that he can help in one case, and of course his asking him to pass a message on, nothing more than that, to Peter Aird, his security guard colleague, who was admitted to threatening me with criminal violence if I entered a court building in 2010. And this is the statement he gave, although it's not actually clear if he ever did give the statement, and obviously I'll come to that in a moment. But the statement was apparently made on the 30th of November, so the same night. He says, I am the above named person and I reside at the address known to police. The address, I think it's supposed to say known to the police. I'm a security guard at Bristol Crown Court. I started my shift at 0700 and finished at 1800. Myself and Henderson Ford were working on the front desk. Henderson Ford is the security supervisor at Bristol Crown Court, and I will now refer to him as Henderson. At approximately 12:50 on Tuesday, 30th of November 2021, I saw a male I know to be Benjamin Gray come down the stairs and put his bag beside the main entrance to Bristol Crown Court. I will now refer to this male as Gray. I will describe Gray as a white male, aged late 40s, slim built, 5'9" tall, short dark hair. He was wearing round glasses, a lilac purple top, and jeans and trainers. He asked for his camera back, as this is kept with security, and asked me if redacted, i.e. that's been censored, was there. I said censored is on holiday for 2 weeks. That's Peter Aird, obviously, in that second bit, certainly. He questioned, saying he had been told different by someone earlier. He became slightly agitated. Henderson told me that I didn't need to tell him anything. Mr. Gray said a word to Henderson that was a name that sounded Middle Eastern. I can't quite remember exactly, but I remember that it was racist and wrong, especially considering Gray did not know Henderson. Henderson replied, that's racist. And that is when Mr. Gray said to Henderson, I'm not racist. I'm ashamed that my grandfather fought in the army for you. Mr. Gray became more agitated. I knew this was wrong and not acceptable, and perceived this to be based on Gray's hostility towards Henderson's race. Henderson has served in the army before, so Gray had no right to speak to him like this. Henderson replied again, that's racist, and Gray said, I'm going to call the police. Gray then started filming on his small camera, which is not allowed inside the court. I tried to calm down the situation and get rid of Gray by saying that I agree with him. This was only so that I could get him to leave the building and keep him away from the building. I did not actually agree with Gray, and I knew that he was wrong. He has caused issues in the building before and has even been banned from the building in the past, so I did not want this incident to escalate further. Henderson also asked Mr. Gray to leave, but Gray said we'd have to get the police to remove him. Henderson then called over the tannoy for any police officers in the building to come down to the main entrance and assist. A number of plainclothes police officers, who I believe were from CID, came down and started talking to Gray in the main entrance. Gray became more agitated when these officers came down. A police officer arrested him and gave him a brief search. Gray got even more agitated with this, saying, "This is homophobic." Together with Henderson and other officers, they took him outside the building. They were talking to him outside when I suddenly heard a commotion. I rushed outside and saw the police officers that had been speaking to him earlier restraining him in the small fenced area outside the main entrance. I saw Gray spitting in the faces of these officers and spitting in Henderson's face. I had to go back into the building to keep acting as security for all the people entering and exiting the court. I did not see Gray get taken away from police. I had to keep going back and forward, keeping people away from the officers detaining Gray. You never know what can happen, and I was afraid for people's safety. I was in observation of Gray for approximately 30 minutes. I observed him from distance of at closest 2 meters. Visibility was clear and my eyesight is quite good. I know Gray from previous incidents where he has caused issues inside the court. I have even acted as a witness in a previous case against Gray. And there's this very bizarre situation where the signature is from a 3159 Lambert G, dated the 30th of November 21. Well, apart from the multiple fabrications in that statement, we do know that Terry Groves is not called Lambert G. I tried to pursue this in trial and find out who on earth Lambert G is or was, or why there was that signature. And with now Judge Ford acting as a gatekeeper to all my questions, it was impossible to get any kind of any clarity as to why Terry Groves' statement is not on the statement. I mean, he did attend and he did say that that was his statement. So it assumed that Lambert is a police officer because the of the number in the front, and the relevant act is not worth going into, but as you can see, the Section 9, the Criminal Justice Act 1967, Section 9 outlines all the things a sworn statement has to include to be relied on or to be submitted or tendered in evidence by the CPS, and includes the signature of the person making the statement. So the statement was completely illegal anyway, because it didn't have Terry Groves' name in for whatever reason, and therefore it didn't qualify under Section 9 of the Criminal Justice Act as a sworn statement. Obviously, the person making the statement has to give the sworn signature, not a police officer on their behalf. We know from the footage itself that almost everything this man is saying is complete lies. We know that Ford approached me. I didn't approach him. He does admit that Ford, immediately tried to prevent me interacting with Terry Groves. This is what I meant by him being a tyrant. And the altercation that then I'm blamed for the entire incident with Mr. He says he doesn't know what Idi Amin means. He didn't know. He just knew it was racist. It's never been explained to me why it's racist, and there's no point in going down that rabbit hole. But it's completely nonsensical from start to finish, including that there's evidence that Mr. Groves himself didn't even make the statement. He said that he tried to calm me down. And that was the reason why he lied to me to say, or claimed that he lied, when he said he didn't hear anything racist from me during the incident. Clearly, if that is true, that the man must be completely and utterly without a brain cell, because clearly, if he tells me that the one shred that was clung to by DS Bell as grounds for detaining me that had a slight ring of truth, bearing in mind the laws on hate speech, enacted by New Labour in the 90s, that if I had been arrested on some suspicion of Section 4A public or Section 5 public order racially aggravated, based on Henderson Ford's allegation, there would have still been issues about whether arrest was justified, bearing in mind it wasn't violent and bearing in mind I had the footage of the incident which could be examined by the officers there and then. But there might have been some tenuous ground to arrest me on that basis. But under breach of the peace, clearly, if I've already got ringing in my ears, Mr. Groves, an independent witness, not independent because obviously he works for Mr. Groves, but giving independent evidence that he didn't hear me say anything racist, then I'm going to think my arrest is even more unlawful than I already know it is, and have even more justification to defend myself against it. So in terms of calming me down, and apart from the fact that Mr. Groves is establishing himself as a liar when he's supposed to be, his evidence is supposed to be credible to some degree. So next on the list of statements is Henderson Ford. He gave his statement on the same day of the incident, 30th of November 21. I am security supervisor at Bristol Crown Court, and I have been in this job role within the court for approximately 4 years. Previously, I worked at Civil Justice Centre for about 3 years in a similar role. I am giving the statement in relation to an incident that occurred at Bristol Crown Court on Tuesday, the 30th of November 2021, involving a male I know to be Benjamin Gray. I know of this male from my current and previous role, as he attends courts and can be disruptive. Gray entered the building and was going in and out of the courts. I informed the court manager, however, as it is a public building, Gray was allowed to be in the building. I informed the court manager of Gray's presence in the building, as he is known to be volatile and sometimes he goes to the public counter and be rude and disruptive, or can be rude, I think is what he meant to say. I have viewed the court CCTV system and can see that Gray entered the court building at 11:58 hours. At 12:38 hours, by the CCTV system, the male entered the reception area and began filming staff. I repeatedly asked Gray politely to leave the building. He replied, make me, and became verbally abusive. Gray became verbally abusive, calling me Idi Amin, you people, and our people have died for people like you being here in this country. At this point, I did say to Gray, you are now being racist. Gray continued to be verbally abusive. He continued to film, and so I took out my mobile phone during turning on the camera, but I was not recording. I did this to disrupt his filming, as he was filming staff and witnesses that were entering and exiting the building. Gray also began pointing closely towards my face. I entered the CCTV room and asked my colleague Mohammed Irfan to ask police officers to attend. There was then an announcement over the tannoy system asking for any police officers in the building to make their way to the reception area. Plainclothes police officers entered the reception area, coming down the stairs. 2 male officers started to engage with Gray, and Gray became abusive to them, calling them dogs. I was asked by a male officer to call for uniform officers to attend. I went into the CCTV room and called the police on 999 and asked for officers to attend the court. I passed the phone to my colleague Mohammed to complete, and I went back to the reception area. Officers continued to try and engage with Gray, and eventually Gray went outside with them. I was asked by a female officer who was on her phone for the postcode of the court. I believe she was calling for her assistance as well. The female officer left, going outside to where Gray was still being dealt with by officers. I stayed in the reception area with my colleague, Terry Groves, and another male officer. The female officer stood in the door area and asked for assistance. The 3 of us ran outside to assist. I saw Gray with his fists raised in what I would describe as a boxing stance. The officers and I then all moved forward to restrain Gray. Gray then began to spit at another officer next to me and myself and another officer. I moved Gray's face to the side so he could not spit at us again. We kept Gray restrained until uniform officers attended and they took over the restraint. A female officer placed Gray in handcuffs. We see no evidence there from Ford as to his saying, okay, let's have a comedy show. No basis for, doesn't refer to in any detail about his demanding that I leave the court building, his refusal to provide any reason. The fact that he uses force isn't mentioned, or comes directly into my space to physically force me backwards into the area that members of the public are coming in from. And his statement, you people, our people have died for people like you. Our people have died for people like you being here in this country is utter fabrication. Nowhere can that be heard in the film footage. It's complete perjury, and what he says is largely irrelevant because all his actions all his verbals were sound recorded and his actions were recorded on CCTV, if not my own GoPro. And the CCTV, of course, for the relevant first 10 minutes, conveniently vanishes. And we have the statement of Joshua Stevens. This was made on the 1st of December 2021. Joshua Stevens was teamed up with Phipps to investigate me, in quotation marks, and under the supervision of Tayyab Hussein, who was the police sergeant who had control of both the officers. Here he deals with what happened to my SD card from the GoPro camera. IMPC, as I say, the statement was made on the 1st of December. IMPC 4714 Stevens of the Avon and Somerset Constabulary, currently stationed at Kenneth Steele House. On 30th of November 21, I was on duty in full uniform and on mobile patrol. I was in company with PC 2447 Phipps and with call sign QPR 165. At approximately 20:45 hours, we attended Patchway Police Station in relation to a prisoner by the name of Benjamin Gray that we had to interview. I was informed that we had to seize his GoPro as he had filmed part of the incident on that device. At 20:55 hours, I seized a Kit Vision GoPro from his property in custody and exhibit this as 4714JS1. I placed this into an evidence bag and sealed this with seal number M26283530. Within the investigation, CCTV has been sent to us from Bristol Crown Court. I exhibit this CCTV as 4714JS1. So, and then there's the bit about me spitting in his face, and well, I might as well read it out. At 23:06 hours, I attended the cell 28 in order to serve section 5051 paperwork on him in relation to the seized GoPro. The cell hatch was lowered and I explained to him in relation to the devices, and then the defendant, without any warning, has spat, which caused spit to hit me directly on my forehead. When he did this, I could hear him bring phlegm up and saw spit particles leave his mouth. I immediately felt this on the top of my head, and this felt disgusting. I tried to close the hatch door quickly as I feared being spat on further, and this caused me to catch my fingernail on the hatch door, causing pain and a lot of blood. At 23:06 hours, I further arrested him for assault by beating of an emergency worker. I had my body-worn video camera on during this incident, which I exhibit as 4714JS3. Nobody had the right to assault me. This felt disgusting, and I fully support a police prosecution. Well, I mean, one might have more sympathy, or any sympathy, for Mr. Joshua Stevens in the later, for what he sets out in the later part of his witness statement, if you ignore the first part of his statement. What does he say in relation to the SD card? He simply says, I was informed that we had to seize this GoPro as he had filmed part of the incident on that device. Well, it's already been taken off me, and it could have been viewed. Well, it could have been viewed before I was even arrested, or any mention of my being arrested, as soon as the officer talked about my being having made racist remarks to Ford, because Bail wasn't interested in my counter allegations that I'd been assaulted by Ford, but he was interested in Ford's allegation against me about verbals. So he could have viewed the footage then. They could have viewed it after my arrest, before they'd actually decided to take me to the Patchway, He's the investigating officer, and he just casually says he put he placed this into an evidence bag, and sealed it with the seal number. He didn't bother to look at the SD card. The SD card contains the sound and the film recording of my engagement with Ford. There is clearly there's no dispute that I've complained about being kidnapped from the outset, and there's no dispute that that I've complained of being assaulted by Ford. Even if they can't, I mean, the irony is, in order to know exactly what I'm complaining about, they would have had to have looked at the footage in the first place. But Phipps takes no interest. Why am I being detained in the police station in the first place? It's for a prompt and effective investigation. The powers under PACE, under Section 24 of PACE, that have been handed to the police officers as grounds for detaining me are a mockery, because they're not detaining me for a prompt investigation. If they were detaining me for an investigation, they would investigate such things as the GoPro footage. And the whole point of having footage, this is why police wear them, why we have CCTV cameras, so that billions of pounds of public payers' money and innocent people are not, billions of pounds aren't wasted, and innocent people aren't detained and arrested or detained for any longer than necessary, based on allegations of what people have said and done, when the footage verifies exactly what they've said or done. So this officer takes no interest. So he's going to keep me locked in a toilet on the utter fabrication that it's in order for a prompt and effective investigation. When all I'm being detained for is to shut me up because I've got evidence that Ford, Bale, Doxey, Edgeworth, et al. Are all just a bunch of crooked, lying, kidnapping, sexually assaulting animals.